malpractice? Well, let's find out with lawyer Magdalene Munsami, who is joining me on the line. If you have any questions, please send them to us on WhatsApp. The number is 0617660355, or you can call us on 01088802396. Magdalene, assalamu alaikum.
Walaikum salam, Mariam. How are you?
Alhamdulillah, shukran, and yourself?
Oh, alhamdulillah, all is fine, thank you.
Thank you for joining me once again. So let's get straight into it. What is medical malpractice?
Okay, when you look at medical malpractice, it's seemingly one of the things that are becoming more and more prevalent in terms of, with the pressures that doctors are under, particularly in instances that there is now more medical opportunities available for people like that of plastic surgery, etc., etc. But that's just an example. Medical malpractice is defined. It's a negligent act or an omission by a medical professional resulting in personal injury to a patient. And what that means is that the standard of practice and care that is meant to be exercised by the medical practitioner has not been. There is a step or there's a failure to exercise the standard of care. And so that is where the medical, which is clear in terms of what that means. It means that an individual has failed to conduct whatever procedure correctly, etc. And it may not have to be a medical doctor. It can equally be a nurse. Remember, there are many people who form part of operations, many members of the medical fraternity, anesthesists, the operating specialists. You have various people involved. So it may not be the doctor itself. It may be another person in a procedure or in some kind of way or another. For example, a pharmacist, where there's a prescription that is given, the pharmacist says to the patient, "Oh no, this wouldn't work for you. You should try something else." So medical malpractice, it's definitely a negligence, or it's an omission to conduct what needs to be done in its full completion.
All right. So, who can an individual sue for medical malpractice?
In many cases, individuals will sue for medical malpractice directly, depending on the nature of the case. One can also report their matters via the Health Professional Council. And what we have, like in South Africa, for example, if a client feels that there was an issue with an attorney, they can have the privilege to sue. They can go to a law society, or they can take the attorney to court. The same with medical malpractice. They can get themselves a lawyer, represent them on issues of medical malpractice, and thereafter take them to court, whether magistrate's court or high court. And of course, then it would have to be the hospital that will have to assume the vicarious liability if the doctor is working, if it's not a private practice. So there's another aspect, whether it's public health care or whether it is private. So that is where the patient will have to consider vicarious liability in the case of it being a public hospital. And here you look at doctors, nurses, even an administrator for that matter. An administrator will have a script, give you the incorrect script, or type out an incorrect procedure, or schedule you for a wrong procedure, etc. So medical malpractice does not just it's not just a doctor that is involved. And then you have to look at, in South African law,
Mm-hmm.
you have to look at the issue of negligence and break down, because if it is negligence or an omission to act in a certain manner and the omission of the standard operating procedure, then you'll have to look at what do you need to prove in order to claim that there was negligence. And did the healthcare professional take as much consideration as possible into the procedure? Did the person apply the obligation of the level of care and treatment that should have been practiced at all times, not necessarily during one? I met a plastic surgeon, and she said to me that the patient did not disclose that he had had high blood pressure before undergoing a very serious plastic surgery on a very sensitive area of his body. And he thereafter reacted to it. But it was the nurse's responsibility to make sure that all of his vitals were in order. So that is where the level of care comes in. And then obviously the breach of a direct, if a person has a direct. Now, in the United States, they refer to it as a 4D, that being duty, deviation, direct causation, and damages. But we don't apply the same 4D principle. Our principle is negligence and ensuring that there is, in every way, a breach of negligence or an omission of an act that caused the patient to suffer this kind of extent of damage. And if it's a direct, so this was it deliberate, not just negligent, but was it intended? And what the extent, and this is where the damages factor come in, to what extent has this person possibly lost an arm if they are a right arm? Or to what extent will there be financial loss, and there will be losses to their family, and they living their normal lives? What will then prohibit them from that kind of thing? So it's not a simple claim to make if there hasn't been, if the damage can be cured. Because the first step would be, if the person was negligent, let us, the medical professional will prove or attempt to prove that, no, I followed all the procedure, etc. And this was a reaction to this that I was not aware of, or it just happened. And there are such things that do happen with the body. However, if, for example, the medical practitioner has caused direct harm, then proving that is the responsibility, obviously, of the patient, and that is important.
All right, Magdalene, how long does such a case of medical malpractice take? I mean, because you did mention that they will have to prove that it was negligence, medical malpractice, so this would take a while.
Look, because it's a civil claim and it's a law, it's a suit for damages and negligence. It will take the form of an action, and so it will be possibly opposed. In all likelihood, it will be opposed if it is not settled prior. I always say, and I always maintain, that any civil, it goes to trial and there has to be much investigation, because you must also remember that people have to keep records, Maria.
Yes.
Of the case of the patient, what was done, what was the nature of the injury, etc., etc. So those things are very critical. And so those things have to be produced. There has to be a lot of exchange of papers. So if it goes to trial, if it's not settled before trial, if it's not relieved or fixed, if the breach or the negligence is not, it may be there was no negligence as well, but if there has been, a trial can take up to 2 to 3 years on a big matter of medical malpractice or medical negligence, for that matter, because there's a lot of proof and ownership. The onus of proof lies on the person who is the plaintiff, the person who's bringing the complaint to court, and hence it will take a lot of time, which is why I always say it is always important and imperative to try and see how best a matter can be settled. Very imperative. And the other thing is that it may be that patients also need to be very conscious of when they sign, when you go into a hospital for procedure, you go to the reception. Many people would know this. You go to the reception and then you sign a form that says, I so-and-so, I'm here for be admitted in this hospital. And then you get a form that if there is any liability or negligence or any mishap that transpires as a result of this procedure, because all procedures are risky. The medical practitioner or anyone else involved will not be liable. Then you will not have a claim. So it is very complex to say, is there a claim or not? You see, if there is that, those are the things that must be done. The other issue is the issue of prescription. We speak about prescription a lot on your show with regard to prescription in respect of time. So if you had your injury, it must your legal your initiation of your action must happen within 3 years, or it falls away. Your time span has passed. The other thing that's always important is to consult. If there's anything that you want to know from your medical practitioner or anything of that nature, consult. Establish what is the issue that it is that you're undergoing. Make sure that there's a thorough discussion with your doctor. And if there are incidents of medical malpractice, which is becoming very frequent, because people are now venturing a lot into, for example, in plastic surgery. You go in there with one condition, you come out with another. I was meeting with plastic surgeons from the Red Cross at Constitute Hospital over this weekend. And one of the discussions that we had was around the fact that there's a certain condition that can't be operated on. And they were insistent that there's no way, even though people say that they can, the consequences of such an operation is that over time that person will lose mobility on the same leg that they have this complication on, that they will relieve temporarily, but they can even become paraplegic.
Okay.
So if, and other doctors are saying, no, we can do this operation, we can do this, there's no problem, we can do this operation. But the reality is that the risks that these procedures come with are not thoroughly considered. So people must be fully aware and consult, especially for something that's very, for anything, but at least consult to medical professionals and establish exactly how they, what would be the consequences, or what is the advice, etc. That's one of the things that I would say to avoid such things as medical malpractice, because very severe, especially this financial loss, if it affects the family and the livelihood and all of that. So yes.
Hmm. Yeah, well, we've heard of medical negligence and malpractice from hospitals in South Africa. You know, like you mentioned, you go in with one condition, you come out with something else. We've
Yeah.
had mothers went to give birth and come back with scissors and scalpels and other medical items in their bodies, which is
Yes.
crazy. So, wow, it's how are medical practice cases like this here settled? I mean, especially of those from government hospitals.
Look, in there you would obviously you would have to see the Minister of Health or the hospital and at the hospital itself. So you'll have two respondents in that
Mm.
case. For that, if you would then take on the hospital, as if you want to take on the Department of Health, you can, because the hospital will say, "Oh, but we didn't have sufficient." If that is the case, in many instances, "Oh, we didn't have this sufficient medical implement
Hmm.
in order to be able to conduct this surgery." But what is important to know, and I'm glad that you raised that, because many people, uh, uh, I've heard of stories where many people find cotton swabs and things in their body,
Mm.
and they're in so much of pain. And this has now started to unwind and start to cut little um, arteries or vessels in the body. And what's important is that you know the 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 medical negligence, proving the negligence, that the
Mm.
person failed to operate with the standard of practice and to do what needed to be done in terms of standard operating procedures, to ensure that there is a consent and that this thing must be properly explained to. So, in cases like this where there is a suit, um, there is the medical expenses. Say, for example, a person had medical expenses from the past as a result of this condition. And
Mhm.
this person then did an operation, and obviously there was an unfortunate incident. That individual can sue for expenses both from the past and present and future medical expenses.
Mhm.
For loss of income. If the person has become incapacitated and a doctor has declared them so, they can sue for loss of income.
Okay.
And general damages for pain and suffering. Those are difficult. That's why it's noted that those are things that require one to understand the complexity of pain and suffering, because you would then have to go to a doctor to, if you are under stress, or if you, for example, general movement is impeded,
Mm.
then what are the implications of that? Um, so obviously we spoke about that in the compensation. It's a, so yeah, we have had that issue. Um, how to pursue, like pursuing a medical malpractice case? Firstly, you need to get the advice of an attorney. A lot of attorneys may say, no, but this is a medical malpractice, this is something else, or whatever the case is, and advise and guide you as to what the process will be about, and then what are also the long-term effects. Because remember, a person who is um, going through a case of medical malpractice, while they are having implications, may need somebody to have power over them, because they may be so badly medically damaged from this procedure.
Mhm.
The best way to get it settled is if you have the right attorney. A lot of attorneys want to litigate in all kinds of matters these days for just to litigate. Um, I believe that litigation is a very important thing in order to settle matters that are of a big nature and there are many disputes. But it's always better to settle, mediate, negotiate with both parties to, one, avoid the financial expenses and the toll that it takes. Now, remember, this person is dealing with a lot of income. Unless they have finances and other means, the medical negligence suit is not one that is the cheapest. But also, this person is medically unwell. So, you would want to advise the hospital to settle the matter, because they themselves don't have the time to have their best cardio practitioners and their best surgeons, neurosurgeons, etc., out of a hospital and in court. So you will say, okay, fine, look, this is what happened. How do we first attempt to correct it? Is it possibly, can it be corrected? And thereafter, that's the first gesture of showing that they've corrected the wrong. Secondly, the claims that come from it, that flow from it. How do they then attend to those claims? So I think that is what is important. You know, I think it was in 2019, the medical negligence claims in the country were over 80 billion rand.
Wow.
And in Gauteng alone was 29 billion rand. Now, let me give you an example. You remember there was a lady who was lying on the floor in a hospital in, was it Steve Biko? No, it was a clinic in Mamelodi.
Yes.
And she was on the floor, and the daughter came to find her mom was left on the ice cold. I think she had asthma, if I'm not mistaken. And nobody attended to her.
Yeah.
Now that is medical negligence. Not it can be malpractice, because there was a negligence. The doctors and the administrators or the nurses who walked past this person had a duty of care. They had a standard of care that they had to exercise, and they failed to exercise it. The issue is, in many public hospitals, it is finding an attorney who will take on a case that will only benefit from a contingency outcome, because many people who go to public hospitals in any event can't afford an attorney.
Yeah.
In most instances, I'm not generalizing, I'm just suggesting that, because public health care is expensive, and they don't expect that they go to a public hospital to come out with with more damage than they went in. And if that is the case, they would obviously have trouble. So they can take the route of asking the attorney or negotiating with the attorney for a minor fee, and then settling for a contingency fee. And if the matter settles, the merrier it is. Which is why a lot of attorneys push for litigation, because litigation then costs money. But my view is always to settle a matter. In that way, your client has got psychological peace of mind, and the opposing party has made pay their remorse. In any event, you're going to go to court, you're going to drag the matter out for the same result that you could have gotten sooner through a settlement. Do you know what I mean?
Yeah.
So for me, that is the A, prize A all the time. The sooner the claim for medical negligence, the sooner the settlement on such a claim, the better than to take it in that manner. And many hospitals, if they can see from the record that there was absolute negligence. I mean, that woman, the woman at this place called the Mamelodi Clinic, there were pictures of her lying there, screaming for help.
Videos as well, yeah?
Videos as well, yes. And people were just, now in a situation like that, you could sue the superintendent or the head of the clinic, you can sue the MEC, you can sue the Minister of Health, because this, you can sue the doctors who were present, whoever passed her, whoever she remembered she spoke to. But she really needs healthcare, and I mean, this is the state of it, of the healthcare in the country. We need to make sure that we are able to correct it.
Yeah, we have a long way to go as a country, especially when it comes to healthcare. I mean, I remember going to a public hospital and having to sit there almost the entire day. You know, you go early in the morning so that you can be in the queue, thinking that you're going to get the help. Meanwhile, you spend the entire day there. Basically, it's a whole working day. That's why sometimes we have to get doctors' letters from them to prove that we were actually at the local clinic or the local hospital. And unfortunately, it's a sad state of affairs, and we definitely have a long way to go. Magdalene, thank you so much for your time, for joining me, and for breaking down this for us. And hopefully we'll chat again soon.
It's a pleasure. Thank you so much, Shukran, Mariam. And I hope you have a blessed day.
I mean, same to you. Assalamu alaikum.
Wa alaikum salam.
That was lawyer Magdalene Munsami taking us through medical malpractice or negligence and what it's all about. Medical malpractice occurs when a hospital, doctor, or other healthcare professional, through a negligent act or omission, causes an injury to a patient. The negligence might be the result of errors in diagnosis, treatment, aftercare, or health management. For further questions, send them to us on WhatsApp on 0617660355. We will be right back.
Breaking stereotypes, moving boundaries, joining hands.